Hello everyone. We are outside today. Hopefully the sound is okay. I will do my best in reading clearly and try to enunciate. We are reading Contempt of Court, the turn of the century lynching that launched 100 years of federalism, by Mark Curriden and Leroy Phillips Jr. We're on page 130. Enter Noah Pardon, Chapter 7. Minutes after Judge Sam McReynolds sentenced Ed Johnson to death, the prisoner was escorted out of the city by Sheriff Shipp and two deputies to the Knoxville jail. Oh wait, I thought we were further ahead. No, this is right. Okay, here we go. The local authorities believed they were rid of Ed Johnson and the turmoil his case had caused. They had fulfilled their promise to follow the law by giving the defendant a procedurally correct trial as required by the Constitution and the statutes of Tennessee. But they also had shown the people of the city who thirsted for vengeance that justice through the courts could be swift and punishment severe. What they didn't count on was Noah Walter Pardon. As a child, Pardon dreamed of being the high sheriff. So fast with his pistol, no outlaw would dare enter his jurisdiction. In high school and college, he aspired to be a prosecutor or even a judge. Now Pardon was about to turn the world of the Hamilton County Sheriff and Judge upside down. In doing so, he would make legal history. Pardon was born in 1865 in Floyd County, Georgia, a small farming community between Chattanooga and Atlanta. His mother was a former slave struggling to exist in the aftermath of the Civil War. She cooked and kept house for two neighboring families. He knew nothing of his father, though people said his dad was white. When he was 6, his mother became extremely ill. Pardon was holding her hand when she died. Unsure what to do, neighbors packed up all of young Noah's belongings, a few toys, clothes, and a Bible his mother had gotten him for Christmas, and took him to a nearby orphanage run by missionaries. There he attended school and did daily chores. By the time Pardon turned 19, he was ready for a new adventure. He moved to Chattanooga and enrolled at Howard High School. To support himself and pay tuition, he worked evenings and worked as a barber. 5 years later, he received his diploma. He accepted an offer to study law at Central Tennessee College in Nashville, where he continued clipping hair. While there, he met and married Maddie S. Broyles, who was 7 years younger. Though everyone else called him Noah, she preferred Walter. In 1893, Pardon graduated at the top of his class. Many job offers following: teaching school, editing a newspaper, and pastoring a church. The newspaper proposal interested him tremendously because he loved writing and he believed knowledge through information was the single most powerful tool in undermining racism. In the end, though, he decided to return to Chattanooga to practice law. As a young man studying sociology and the Negro's place in America, Pardon became a disciple of Booker T. Washington, the leader of the Tuskegee Institute. Washington shunned conflict with white agitators. He believed black people should forego immediate attempts to secure their full civil rights under the law. Instead, he taught that black people would obtain a greater degree of respect and acceptance from white people by better educating themselves, cultivating farming and industrial skills, keeping out of legal trouble, and working hard. To encourage or invite confrontation with white people, he said, would only deepen their mistrust and prejudices against black people. Washington promoted vocational training for black people, not intellectual pursuits. Hardin was in the audience in 1895 to hear Washington speak at the Atlanta Cotton States and International Exposition. Hardin would frequently cite that speech, referred to as the, quote, Atlanta Compromise, unquote, in articles he wrote for black newspapers across the South. The lawyer believed that the economics of society would eventually bring the two races together. Washington said the races could be as separate as five fingers in their social lives, but had to be as united as the hand in gaining economic prosperity and legal justice. Hardin was also fervent in his religious beliefs. He never missed Sunday morning worship at his church, prayed before every meal, and spent several minutes on his knees each night before bed. He refused to drink alcohol, use tobacco products, or eat pork. Quote, the body is the temple of the Holy Spirit, unquote, he said. At age 41, Hardin had built himself a successful, if barely profitable, law practice. He was certainly the most successful black attorney in Chattanooga. He and his partner, Stiles Linton Hutchins, represented nearly 2/3 of the black people who got into trouble for stealing, fighting, assaulting, and loitering. Defended a few murder suspects, handled the lion's share of the civil cases filed by black people, represented several of the smaller black-owned businesses in town, and executed most of the real estate transactions within the black community. As a lawyer, his status among Chattanooga black people was rivaled only by certain preachers and his law partner. Despite having no shortage of clients, the lawyers faced a significant problem. Most of their clients had no money to pay them. Poor black clients seemed to expect the lawyers to represent them for free. The black people who did have money would frequently go to a white lawyer if they got into trouble. Though Hardin was certainly respected as an attorney in the black community, the general perception was that white lawyers were afforded more respect by white judges and white jurors. When payment for services did come, it was more likely to be an invitation to a home-cooked dinner at a client's house. Paying black clients were so scarce that one story tells of a black lawyer who actually postponed his wedding when a client ready to pay cash showed up unannounced that morning. In 13 years of practice in Chattanooga, Hardin never had represented a white man. His many offers to assist white people were always rejected. The fact that black people were systematically excluded from serving on juries in Tennessee and throughout the South only aggravated the problem. Litigants did not want a black lawyer if it might offend the all-white juries. As a result, poor black people would also turn to white lawyers if they were involved in a more lucrative civil lawsuit. To help attract more paying clients, Hardin advertised in the local black newspaper, The Blade. As a trial lawyer, he knew the law as well as anyone else in court. Most attorneys in those days didn't attend law school. Instead, they received their law licenses after studying for 3 or 4 years under an experienced trial lawyer. Such a mentoring program was called, quote, reading law, unquote. There are a few states, such as Virginia and California, that still offer such programs. Hardin was a law school trained attorney. His grasp and understanding of common law, the Constitution, state and federal statutes, and previous court rulings were far superior to those of many of his colleagues. His courtroom skills were equally as formidable. The well-spoken pardon employed simple trial techniques, devised a strategy in a case and never depart from it, he told younger lawyers, and, above everything else, develop a story you can tell to the jury that helps your client's cause and is supported by the facts. Many of Pardon's biggest level victories were in civil cases. His tenacious attacks on the insurance companies made the plaintiff's bar extremely proud. Insurance companies made a lot of money selling policies to black families and minority businesses. However, claims filed by black policyholders were systematically denied because the companies didn't think the owners of the policies would sue them. Pardon made them rethink their strategy, and he made some money in their process. Realizing that many of his clients had no money to pay him, Pardon became an early contingency fee lawyer. He agreed to represent people for free. They paid him nothing if he lost, but if he won the case, the client shared a portion of the judgment with the lawyer, a proposition the clients readily accepted. Pardon developed a consistently winning strategy against the insurance companies. He told the all-white jurors to keep in mind that if big insurance firms were allowed to cheat black policyholders, white people would be next. The civil practice financed Pardon's handling of criminal cases. Very few of the people he represented who were charged with crimes had any money to pay. He accepted more pro bono criminal cases than any other lawyer, black or white, in the city, and he fought hard for them, frequently appealing to the Tennessee Supreme Court cases that most lawyers and judges believed were fruitless. That's not to say that Pardon believed all his clients were innocent. To the contrary, if he had a fault in the eyes of the local criminal defense bar, it was that he didn't vigorously defend the clients he knew were guilty. Instead, Pardon would encourage them to plead guilty and accept their punishment. In articles he would write for black newspapers across the South, including the Atlanta Independent, Pardon frequently expressed disappointment in the conduct of his own race. Quote, "Achievement, and achievement alone will subdue the hate-mongering. Many colored complain to me that they are not treated equally by the whites. Why should the whites not look down on the Negro when he acts as he does? We shame ourselves by frequenting the taverns. We shame the Negro race through thievery and drunkenness and improper conduct. Negroes who violated the law should not seek to avoid punishment, and law-abiding Negroes should not protect Negroes who steal or cheat or violate another person." Unquote. As the city's premier black attorney, Pardon had watched the Johnson case unfold. Like the rest of the community, he was outraged at Nevada Taylor's rape. He felt relief when the authorities made an arrest. Though he was disheartened when a lynch mob threatened to storm the jail, his faith was partially restored when local authorities repelled the mob and took the necessary steps to protect the defendant, especially a black defendant. But dismay set in once again when he heard that the judge refused to delay the trial and rejected or discouraged the defense attorney's request to move the case to another city. Pardon was no different from other residents of Chattanooga in assuming that Johnson was the culprit. If he was guilty, the lawyer believed, Johnson should probably spend the rest of his life in prison, or even pay with his life. No one ever accused Pardon of being soft on crime. He was no opponent of the death penalty, and he advocated lengthy sentences for those who committed violent crimes. But Pardon also knew the criminal system, especially when it came to a case involving a black man accused of raping a white woman. To white people, there was no greater indignity, no sin more vile. The first official association Pardon had with the Johnson case came when Louis Shepard walked into his law office about a week before the trial. He admired the former judge tremendously. Shepard was the only lawyer in Chattanooga who was not afraid to stand up against the establishment when defending the rights of a client, and he was one of the few white lawyers who welcomed poor black people as clients. For those reasons, Pardon had worked to befriend the older lawyer. Pardon had earlier rejected Shepard's request to join the defense because the case was too political and too socially divisive. He did help Shepard track down several of the black alibi witnesses. At the former judge's behest, Pardon checked with his sources throughout the black community regarding Johnson's background and character. He also canvassed the community to see if anyone could provide information pointing to the guilt of Johnson or any other person. Through this limited research, Pardon became convinced that the authorities had the wrong man. Every person who knew Johnson said he never raised his voice, never fought, and seldom cursed. No one had ever seen Johnson become violent or even angry. At the same time, rumors about other suspects permeated the black community. A few names surfaced. Pardon passed them on to Shepard, who gave them to the sheriff, but no additional investigation was ever done. There also was widespread speculation that Miss Taylor's attacker was not even a black man, but a white man who had painted his face black. Pardon found two witnesses in the St. Elmo area who said they had seen a man they thought was a Negro washing his face about 7 p.m. When they saw the man wash his face in what appeared to be black polish dissolve, they realized he was really white. However, the two witnesses were black. They didn't approach the sheriff because they believed he would not accept their story. Pardon also had several discussions with Johnson at the jail during the trial. He would arrive at the jail early in the morning to meet with his clients to prepare them for court, and would take a few minutes to chat with Johnson, who initially shared a cell with two of Pardon's clients. Hours after Judge McReynolds condemned Johnson to die, Pardon received a visitor at his law office. It was Skinbone Johnson, Ed's father. The lawyer brought his guest a chair and a cup of tea. Together they lamented over the details of the trial. Pardon told the elder Johnson that his son's trial had been a sham and that several of his constitutional rights had been violated. The lawyer wondered why Mr. Johnson and Ed's other relatives had not attended the trial to show their support. Speaking very slowly, the older Johnson said he wanted to watch the trial and be with his son, but policemen had told him that no visitors were allowed in the courthouse. It was at this point that Skinbone Johnson made his intentions known. He had spoken to his son before the sheriff transported him to Knoxville, and he didn't want to die. Ed did want to appeal, and he wanted Pardon to represent him. Pardon didn't know what to say. Just a week or so earlier, he had totally rejected the idea of defending Johnson. The defendant had good lawyers, some of the best in Chattanooga. Though Pardon certainly believed Johnson had not received a fair trial and was most likely innocent of the crime, convincing the Tennessee Supreme Court that there was reversible error was a far different matter. The elder Johnson said he didn't have any money to pay for an appeal. Instead, he thought Pardon would agree to handle the case simply because he and Johnson were Negroes. Pardon said he would think about it, but he warned that he was inclined to turn down the request. His plate was full of tough cases and he was doing for free. Unbeknownst to Pardon, his law partner was in the next room listening to the entire conversation. Styles Linton Hutchins was Pardon's alter ego. As quiet and patient and unassuming as Pardon was, Hutchins was the exact opposite. His speeches were filled with blistering attacks on the, quote, lily whites, unquote, who denied rights to black people. He was a follower of W.E.B. Du Bois. Du Bois believed in developing the intellect of the black man, not just encouraging him to get vocational training. He believed in freedom and civil rights now, not settling for them in the future. In a society dominated by the Ku Klux Klan, lynch mobs, and Jim Crow laws, Hutchins believed that the means of achieving equal rights under the law was agitation and protest. He filed unsuccessful lawsuits fighting the segregation of the train and trolley systems. He sued the city for refusing to allow young black children to participate in summer athletic programs, and he encouraged other black leaders to speak out and fight against the injustices they suffered. As in this article he wrote for the Washington Bee, a black-owned newspaper, quote, "The Constitution says the Negro has all the rights of the white man. Yet, we are afforded none of the white man's protections. The Constitution says the Negroes are a free people. Yet, we enjoy none of the white man's privileges. The Constitution says the Negro is equal. Yet, we cannot ride on the white man's train. We cannot sit as a juror in the white man's court. We cannot send our children to the white man's schools. The Negro is not equal. The Negro is not even free. The Negro is simply a dark body who is spit upon without any opportunity for recourse." Unquote. At age 53, Hutchins was a veteran lawyer and politician who lived an atypical life for a Southern black man. He was born in Lawrenceville, Georgia, a suburb of Atlanta. His father was a wealthy artist who paid for his son to get a college education at Atlanta University. After teaching school for several years, Hutchins enrolled in the law program at the University of South Carolina. In 1875, he became one of the first black students to graduate from the school. That year, Hutchins moved back to Atlanta and opened a law practice. Judges and lawyers in Georgia had never before encountered a black attorney. They didn't like it and wanted to find a way to stop it. The Georgia legislature took immediate action, passing a law that required lawyers who had received their law degrees in other states to undergo an examination by the county's presiding judge. The law was specifically designed to discourage black lawyers from moving from northern states to Georgia. But Hutchins would not be deterred. He vigorously fought the law. After 6 months of antagonism, he finally convinced an Atlanta judge to admit him to practice in the state court system. In doing so, Hutchins became the first black person to be admitted to the Georgia bar. Then, in 1881, weary of the repeated personal attacks by judges and fellow lawyers, he moved north to Chattanooga, where he perceived the racial attitudes to be more accommodating. He enjoyed immediate success, becoming one of Chattanooga's prominent and respected lawyers. In 1886, the Republicans asked Hutchins to run for a state legislative seat against a very popular Democrat, who was white. Hutchins was attacked by the Chattanooga News as an, quote, unprincipled, crooked, rogue, and dishonest, unquote. In a political shocker, Hutchins won 2,742 to 2,734 by a mere 8 votes. However, the newspaper never let up on him. Less than a month after he had been elected, the newspaper reported that a group of leading Democrats considered banding together, capturing Hutchins, taking him to a secluded spot, horsewhipping him and giving him 24 hours to leave town. Despite the constant criticism, Hutchins served the district with distinction. In 1888, Hutchins left politics to focus on his law practice. In 1888, Hutchins left politics to focus on his law practice and to become an ordained minister. He loved preaching, and his hellfire and brimstone manner was a favorite throughout southeastern Tennessee and northwestern Georgia. He felt no shame in using the pulpit to sermonize against those in government who exhibited racist or segregationist views. By the time the Johnson case arrived, he was one of the oldest black lawyers in the South. Many people in 1906 believed Pardon and Hutchins were a perfect fit. Together they published a small newspaper called The Independent Age, which circulated within the black community for a couple of years. And they joined with the other black businessmen in starting up ventures that ranged from a grocery store to a barbershop. But the first love of both men was the practice of law. Neither had children, so they referred to the practice as their, quote, firstborn, unquote. They believed God had made their law the law their calling. Accompanying Skinbone Johnson to the door, Pardon shook the old man's hand and renewed his promise that he would give the appeal serious consideration that weekend. Pardon was watching the elderly man walk away when a familiar voice interrupted his concentration. It was Hutchins, who wanted to talk. I know, Pardon said, according to his federal court testimony. You think I should take the case? Quote, I think we should take the case, unquote, replied Hutchins, who had overheard the conversation from the next room. Quote, you get crazier every day, unquote, Pardon joked. For 4 hours that Saturday evening, the two men talked about Ed Johnson and his case. Mainly, it was Hutchins talking and Pardon listening. Hutchins made the arguments why they should accept the case. Pardon tried to poke holes in each point. They bickered over costs. They debated the negative impact pushing the appeal would have on their law practice and their reputations. And what if the lynch mob came after them? To Hutchins, none of it mattered. As lawyers, they were bound by the law to defend an innocent man, to right wrongs, to pursue justice, he contended. Besides, Hutchins had experienced all the threats before. Once a judge threw the lawyer in jail because he had asked the court to reconsider a ruling. Another judge banned Hutchins from his courtroom when he dared to point out that the prosecutor was not following the law. Pardon argued that the defendant already had lawyers, including one of the best in the city, Louis Shepard. If those white lawyers couldn't help him, what chance did black lawyers have? The senior lawyer finally won by employing a biblical principle. Quote, much has been given to us by God and man, unquote, Hutchins said. Quote, now much is expected, unquote. Pardon hated it when Hutchins quoted scripture to prove a point, mainly because he knew the older lawyer was probably correct. Finally, Pardon relented, conceding that representing Johnson was the right thing to do. They agreed to meet the following afternoon to devise a strategy for the appeal. That night, Pardon broke the news to his wife, Maddie. They both knew about the threats the white lawyers had received prior to the trial. They could only wonder what they would have to endure. Maddie fixed her husband for 13 years a cup of hot mint tea, his favorite. Little did they realize how much their life was about to change. That night, Pardon retrieved his bookshelf retrieved from his bookshelf the tattered Bible his mother had given him as a child. He opened it to the book of Job. Lying in bed next to his wife, Pardon read all 42 chapters. He had read the story many times before. Each time, it reinvigorated his faith and determination. According to the Bible, Job was a, quote, man that feared God and shunned evil, unquote. As a result, God had blessed Job with 10 children and great riches. Unbeknownst to Job, God and Satan were in heaven debating his loyalty. God claimed Job would be faithful to his beliefs, regardless of the circumstances that befell him. Satan contended that Job would curse God if his prosperity turned to tragedy. To prove his point, Satan sent Job's enemies to slay his servants and steal 500 yoke of oxen and 3,000 of his camels. Fire fell from heaven and destroyed 7,000 sheep. And a great wind knocked down the walls of his house, killing his only 3 sons. The second day, Satan, quote, smote Job with boils from the sole of his foot onto his crown, unquote. Even Job's wife suggested that he end the suffering. Quote, curse God and die, unquote, she said. But Job refused and remained unwavering in his faith. As a result, God blessed him with twice as much wealth as he had previously had, and gave him 7 more sons. Quote, so Job died, being old and full of days, unquote, Pardon said to his wife, reading the last verse in the book. He prayed that night that he would be so fortunate. Louis Shepard walked onto his front porch early that Sunday morning to pick up the newspaper and found Pardon sitting on the steps in his Sunday best. Immediately, the former judge knew it meant trouble. After the pleasantries, the 2 men moved their conversation into Shepard's study. Pardon told him about Johnson's father's visit to him the day before and the subsequent discussion with Hutchins. They had made up their minds that they would file a motion for a new trial on Monday and pursue an appeal. Shepard nodded in total agreement. He had been adamantly opposed to waiving Johnson's right to appeal. And for 2 days, he had regretted not speaking up. There were real problems with how the trial was conducted, Shepard said. He thought there was a good chance that the Tennessee Supreme Court might find there were errors and reverse the conviction, and he offered his full support and cooperation in the effort. For the next 2 hours, Shepard and Pardon relived the entire trial. As Shepard spoke, Pardon took notes. Together they came up with nearly a dozen points that lawyers believed could constitute violations of the defendant's rights. There were numerous trial irregularities, not to mention the judge's obvious prejudices. They began drafting a petition seeking a new trial to present to the court. Nearing the end of their discussion, Pardon blurted out that he and Hutchins needed more than just Shepard's assistance in the case. They requested his direct involvement in leadership. They wanted him to be co-counsel. Shepard took a deep breath and closed his eyes. He knew if he agreed, he would face tremendous criticism from local lawyers and judges and could become a political and social outcast in his own community. But Shepard had never backed away from doing what he thought was right, and Pardon had helped him in the previous case. It was time to repay the favor. The older lawyer simply nodded. Quote, Judge Shepard grasped my arm and held it tight. Then, he told me that Judge McReynolds and Sheriff Shipp would be very angry at any decision to appeal. He said they would fight our efforts, and he said there'd be significant consequences for each involved. And he told me to be certain that I was ready before I formally filed the petition. Only then did I fully realize the difficulty that faced us." Unquote. Pardon in a speech at the Galbraith AME Zion Church. Chapter 8. The appeals begin. Noah Pardon and Stiles Hutchins arrived at the Hamilton County Criminal Court early Monday morning, February 12th, to make their move. Judge Sam McReynolds stepped into the courtroom to find the two black lawyers seeking to approach the bench. Unaware of their intentions, the judge invited them forward. Pardon stepped up, telling McReynolds that they planned to file a motion for a new trial and, if he permitted, an appeal in the case of the state of Tennessee versus Johnson. Hutchins said he wanted to, quote, relieve the judge of the burden of the defendant's life, unquote, by appealing the case to the Tennessee Supreme Court. McReynolds was stunned. He didn't know what to say. Pardon said he had drafted a one-page request for a new trial. The lawyer asked the judge to authorize the court stenographer in the case to prepare a written transcript of the trial to submit to the state's highest court, as is required by law. The judge denied his bid for a new trial. Judge McReynolds sat back in his chair to ponder his next move. The last thing he wanted was to delay the execution of Johnson. He had to find some way to stop the appeal. Then it came to him. The judge called Pardon and Hutchins to the side of his bench. He told them to come back the next morning to file their motion formally in open court. That way, he said, the prosecutor could be present and the motion could be properly heard. Quote, "We should file the motion tomorrow?" Unquote, Pardon inquired. Quote, "But that would be the fourth day following the verdict, and local court rules the motion for a new trial must be filed within 3 days." Unquote. "But you're counting Sunday." Hutchins spoke up. Quote, "The judge has never counted Sunday against the defendant." Unquote. The two lawyers looked at Judge McReynolds for a response, but he only raised his eyebrows and nodded in apparent agreement. The next morning, Pardon and Hutchins slipped into court at about 10 a.m., just as Judge McReynolds called a recess in the case he was hearing. During the break, the lawyers approached the bench. Pardon handed the clerk of the court his petition, officially seeking a new trial for Ed Johnson, and began to make his plea. Quote, "Your Honor, I ask the indulgence of the court and beg permission to file a motion for a new trial in the Johnson case. I have been impressed by the general opinion that a mistake may have been committed when Ed Johnson was convicted. If there was no question about his guilt, no one would dare to make a motion for a new trial. But public sentiment is divided on this subject. I have had many white people speak to me about this matter, and as the Constitution allows any man, be he white or black, the right of appeal, I do believe that it is our duty to allow the Supreme Court to pass upon this case." Unquote. Assistant District Attorney E.S. Daniels jumped to his feet to object. The prosecutor said Johnson had 3 lawyers and they had waived his right to appeal. How could Pardon Hutchins now come forward and claim to represent Johnson when the defendant was 100 miles away in Knoxville? Pardon said that Johnson's father had authorized them to file the motion for a new trial, and the lawyer believed that was sufficient. Daniels countered that Johnson was 23 years old and fully capable of making a decision regarding who should represent him. Then, the prosecutor told the judge that the rules of the local criminal court required lawyers for defendants to file motions for a new trial within 3 days of the verdict. A motion for a new trial was legally essential before an appeal could be made in a Tennessee case. The jury had returned the guilty verdict Friday. This was Tuesday, 4 days later. The time limit for filing a motion for a new trial had expired. The motion should thus be rejected immediately, Daniel said. Pardon argued that he had been employed by Johnson's father only Saturday, and that he was still trying to learn all the facts of the case. He said Sunday had never been included as counting against the 3-day rule. Besides, Pardon continued, Johnson's lawyers had abandoned their client following his conviction. The, quote, declaration to Johnson by his lawyers that the defendant had a choice of dying at the end of a lawful rope or one applied by the mob is sufficient evidence that he was abandoned, unquote. The defendant should be granted the opportunity to seek an appeal because his initial decision was made under duress. Judge McReynolds interrupted Pardon in mid-sentence to say he had, quote, never witnessed a trial that was conducted more fairly, unquote. He said, Johnson and his lawyers were given every opportunity to defend against the rape accusations. The judge then blasted Pardon and Hutchins for attempting to override the rules of his court. He said there were many men sitting in the state penitentiary who had simply failed to file their motion for a new trial on time. Lawyers had 3 days to file the petition, he said, and Sunday was included. The only exception was if Sunday was the 3rd day following the verdict, the reason being that the court was closed on Sunday and no filings could be made then. Such was not the situation in this case, McReynolds said. Finally, the judge laughed out loud at Pardon and Hutchins and publicly scolded them in front of the other lawyers. Quote, what can 2 Negro lawyers do that the defendant's previous 3 attorneys were unable to achieve? Do you know the law better than this court or the lawyers who represented the defendant? Are you aware of some legal principle that I have never heard of? What can a Negro lawyer know that a white lawyer does not? Do you think a Negro lawyer could possibly be smarter or know the law better than a white lawyer? Stunned by the judge's spirited rejection of their motion, Pardon told the court he understood the ruling. However, he said, since the trial court would not grant his motion, he would file an emergency petition with this Tennessee Supreme Court seeking a stay of the execution. The lawyer said he also desired Judge McReynolds' blessing in obtaining a transcript of the trial. He needed an official transcript to show the appellate court the errors that had occurred during the trial. But the judge said he would do nothing to condone their efforts, which he described as a waste of time and a personal rebuke to himself and to the 3 attorneys who had defended Johnson. Outside the courtroom, Pardon and Hutchins were dumbfounded. They had been tricked, set up for failure. The day before, when Judge McReynolds clearly told them to return the next morning to file their motion, he had to know that he would reject their petition on procedural grounds. He also knew they had had their petition ready to file the previous day, but he had turned them away. The opposition by the judge would certainly make their task more difficult. If McReynolds had agreed to hear their motion for a new trial, Johnson's execution would have been delayed automatically, pending the arguments on the petition and any other appeals. But now the defense attorneys would have to work at a fevered pace to file the appropriate petitions and supporting documents with the Tennessee Supreme Court. Because Johnson was indignant, the court could have given the lawyers a copy of the transcript of the trial at the state's expense. Now they had to raise money to get the document. It would not be cheap. Time was running out. Johnson's scheduled hanging was only 28 days away. The lawyers hoped that black churches and business leaders would step forward to donate money to pay for the appeal. They spread the word that this case was not simply about Ed Johnson and his innocence, nor was it even about race. Pardon wrote in an article in the Atlanta black newspaper, Voice of the People, quote, "For the sake of justice, we take up this case. Not just because Johnson is a Negro, but because he is a man who has rights, God and man have granted him under the law, and because the evidence against Johnson did not satisfy the opinions of many men, white and black, of his guilt. This is a state and nation of laws, and all men by nature are equally entitled to life, liberty, and the pursuit of happiness. The laws neither favor the white man nor suppress the Negro. We rise up in righteous indignation against the tyrannical use of those laws against the human being. We fight Fred Johnson because the Declaration of Equal Rights to all docs not apply only to the white man. The Constitution protects all men." Unquote. Pardon and Hutchins quickly realized the black community would not be offering them much support in their endeavor. The plea to black ministers for money to pay for their trial transcripts resulted in no donations. The case had been so criticized by leading white people in the community that black leaders hesitated to do anything that could be viewed as helping the culprit. By Thursday afternoon, February 15th, the lawyers knew they were alone in their fight. Times were about to get considerably tougher. Many of their longtime white friends and associates shunned them, but their biggest shock was that their neighbors in the black community turned their backs as well. In 48 hours, Pardon and Hutchins had become outcasts in their city and from their own race. The word was out. If you're black and charged with a crime, and if you desire leniency from the sheriff, prosecutor, or judge, do not hire either of these black lawyers. Potential clients went elsewhere for representation. Current clients searched for new lawyers. The most devastating blow to Pardon came when his pastor, the Reverend W.B. Fleming of the St. James Baptist Church, criticized him. Quote, "Now for these colored attorneys to undertake to reopen the case is calculated to stir up trouble between the races," unquote, the preacher told the Chattanooga News. Quote, "The best element of the colored people do not approve of reopening the case, and the colored lawyers who are advocating it making a serious mistake, not only for themselves, but for the community in which they live," unquote. Attempts by Pardon and Hutchins to prepare the appeal were being thwarted, or at least delayed, by court officials at every turn. The court stenographer required that the money be paid to him in advance. In previous cases, he had accepted partial payment with a credit arrangement for the remainder. At the clerk's office, secretaries said the case file was still in the judge's chambers, and they could not retrieve it. The lawyers needed the actual court file to confirm dates, read motions filed by the prosecution and defense attorneys, and examine the written orders issued by the judge. The lawyers finally got enough money Friday morning to pay the stenographer. However, court transcripts filed on appeal must have the signature of the judge certifying that the documents of the proceedings were authentic, true, and accurate. And an hour before the court reporter turned the transcripts over to the attorneys, Judge McReynolds quickly and quietly slipped out of town on a previously announced week-long vacation to Florida. Tuesday morning, February 20th, Pardon boarded a train to Nashville. The lawyers working with Shepard had prepared a writ of error claiming that Johnson's trial was flawed and that he deserved a new one. They also drafted a writ of supersedeas, which asked the court to take emergency steps to postpone the execution of their client. Later that day, Pardon hand-delivered the documents to the state Supreme Court. The writ of error focused on 3 primary points. Quote, "The evidence in the case did not warrant a conviction." Pardon argued that the jury should have found Johnson not guilty. The law in Tennessee and most states permitted state appellate courts to reverse a lower court conviction if the state justices found that the evidence during the trial actually demonstrated the defendant's innocence rather than his guilt. During the trial stage, prosecutors were saddled with the burden of proving the defendant guilty beyond a reasonable doubt. Once the judgment of conviction was rendered by the jury and confirmed by the trial judge, the burden of proving guilt or innocence for the purpose of the appeal automatically shifted from the state to the defendant. Because it was extremely difficult for defense attorneys in any case to prove from the evidence introduced during the trial that the defendant was really innocent, very few guilty verdicts were overturned. 2. A lynch mob mentality permeated the entire trial and placed undue pressure on the jury to convict the defendant. In the Tennessee Constitution, the quote, law of the land, unquote, clause guarantees every person facing criminal charges the right to a fair trial and to due process. Pardon claimed that the lynching attempts on Johnson's life had so contaminated the community, and thus the jury pool, that Johnson could not receive a fair trial in Hamilton County. 3. It was improper to allow a juror to rush toward the defendant during the trial and scream, quote, if I could get at him, I would tear his heart out, unquote. The action of the juror pardon claim proved that the jury was biased against the defendant and was being motivated not by the evidence in the case, but by emotion. The incident demonstrated just how tainted and unfair the trial was against Johnson, unquote. If the state Supreme Court agreed to review the case, it wouldn't hear the arguments until September term. That meant Johnson's death sentence would be automatically stayed until the fall. The justices would then only have to find the one of the three claims was applicable in order to reverse Johnson's conviction. Most lawyers in Chattanooga believed Pardon and Hutchins had no chance of prevailing. The Tennessee Supreme Court was very conservative and extremely law and order in outlook. The state justices had not reversed a death sentence in a decade. Neither Pardon nor Shepard could remember the last time the court had stopped the execution of a black man. Yet, they had to continue preparing their arguments, just in case the justices agreed to hear their petition. On Saturday, March 3rd, the state's highest court issued its unanimous decision. State of Tennessee versus... Damn. Sorry, y'all. That was probably really loud. My bad. State of Tennessee versus Ed Johnson. The record in this case had been presented to the court with a petition for writ of error and super sedeas. Upon examination, we find that though a death sentence was pronounced upon the petitioner, yet the motion for new trial was not acted on by the trial judge, and the record does not contain a bill of exceptions. In view of this, we have given the technical record a most scrutinizing inspection to see if serious errors were there to be discovered, but have been unable to find any. We are unable to find any error which will authorize the issuance of a writ of super sedeas. As a writ of error would be of no avail without that writ, it is denied. The petitioner, however, can file with the clerk the record of a writ of error will be issued to him by that officer as a matter of right under the statute. This cause comes to be heard upon a petition for writ of super sedeas upon consideration, where the court declines to grant said writ, and the petition is therefore dismissed. It is ordered that the court stand adjourned until Saturday morning, March 10th, 1906, at 9:30 o'clock. Tennessee Chief Justice W.D. Beard. Without the writ of supersedeas, which would have prevented Johnson's execution, the right to pursue the writ of error was useless. Johnson would already be dead. So certain were Sheriff Shipp and Judge McReynolds that Johnson would be executed as scheduled on March 13th that they ordered deputies to begin stretching out the hangman's noose. To do so, the officers tied one end of the rope to the wooden gallows and weighted down the loose end with a 100-pound rock. Their goal was to eliminate all the kinks and slack in the inch-thick hemp. Pardon, Hutchins, and Shepard had prayed for victory, but expected rejection. Even as Hutchins prepared to present the defense's case to the state Supreme Court, Pardon and Shepard worked on an alternative means of saving their client. Wednesday afternoon, March 7th, the sheriff boarded the train for Knoxville to get Johnson and bring him back to Chattanooga. Shipp, sitting in all the white first-class cabin, didn't realize it then, but Pardon was on the same train. The lawyer was seated in the general boarding section for any person who was not white. The train offered no first-class amenities to black passengers. 3 hours later, they arrived in Knoxville. Pardon stepped from the train and went to the Knox County Jail to get his client's approval of the petition. From there, Pardon walked to the United States Courthouse to ask a federal judge to intervene in the case. In a 9-page document called, quote, a petition for writ of habeas corpus, unquote, Pardon contended his client had not received a fair trial, was illegally facing a sentence of death, and had been denied several of his federal constitutional rights. Pardon filed the petition under the Habeas Corpus Act of 1867, which Congress passed to allow defendants in state criminal cases to seek relief in federal court under certain circumstances. The law allowed any persons tried in a state court to seek a federal judge's review of their cases, if they believed they had been imprisoned in violation of their federal constitutional rights. The U.S. Supreme Court held in 1895 that federal habeas corpus relief was available in any case in which the state court lacked jurisdiction or in which the state court had deprived the defendant of due process of law or equal protection under the law. Though it may have been easy for criminal defendants to appeal their conviction under the federal statute, it was nearly impossible for them to win relief. Neither the U.S. Supreme Court nor Congress had set down exactly what federal constitutional rights belonged to individuals. In fact, the justices had declared that the Bill of Rights was not binding on the state court system in criminal cases. The justices did not recognize a criminal defendant's rights to effective counsel, right against self-incrimination, right against illegal search and seizure, or right to a fair trial until decades later. The Habeas Corpus Act, followed by Pardon, also did not permit federal judges to reconsider the evidence in the original trial presented to the jury, and did not allow the jurists to pass judgment on the defendant's guilt or innocence. As a result, most trial lawyers believed federal habeas petitions were a waste of time. Many attorneys never availed their clients of their procedure, since the petition was almost always denied. In 1906, it was viewed as nothing more than a tactic to delay punishment. Pardon contended that the primary issue in the Johnson case was, as in most criminal cases, whether the defendant had received, quote, due process, unquote, under the law. Under the 14th Amendment to the U.S. Constitution, every person is entitled to due process. But in 1906, the federal court's interpretation of the due process clause was very narrow. A problem Pardon knew he had to overcome. A defendant received due process if the criminal charges were based on an existing law, if the trial was conducted as procedure required under state law, and if the defendant was given the opportunity to be heard during the trial. Law enforcement tactics such as beating a confession from a witness or defendant, presenting evidence known to be false, or suppressing evidence pointing to the innocence of the defendant were not considered violations of a state criminal defendant's rights in 1906. So weak and ineffective was the due process clause that pardon could not find a single case over the previous 40 years in which the United States Supreme Court or the federal courts had reversed a state court conviction on the basis of it. Even so, pardon was convinced that the facts in the Johnson case would be the exception. Employing the Equal Protection Clause of the 14th Amendment was just as difficult and impotent in reversing state court convictions. Pardon could find only one case since the Civil War in which the U.S. Supreme Court had reversed a state court criminal conviction based on an equal protection claim. But that one case appeared to give pardon the opening he needed. In 1886, the High Court ruled that states and counties that systematically kept black people off juries by not putting their names into the jury pool were violating the Equal Protection Clause. Unlike the Bill of Rights, the 14th Amendment specifically did apply to all state courts. And pardon was confident the Johnson case involved the very cause of action that justices had 20 years earlier declared illegal. The intentional exclusion of black peoples from juries. Of the 36 people summoned for jury duty in the Johnson case, not one was black. Neither Pardon, nor Hutchins, nor Shepard could remember a single instance when a black person had been called to serve on a jury. This was proof that black people were being excluded from the jury pool, they argued. This issue alone should have been enough to encourage the federal courts to review the case. The petition also claimed the state court had violated numerous other rights belonging to Johnson, including his right to a fair and impartial trial, his right against self-incrimination, and his right to appeal the conviction. However, the lawyers knew that these claims were a long shot. The federal courts had never recognized that people on trial in state court had such rights under the U.S. Constitution. But because the facts were so egregious in the Johnson case, Pardon and Hutchins believed that their time could be right for the courts to recognize additional federal constitutional rights to defendants in state criminal cases. The lawyers knew they were seeking what amounted to a legal revolution. They were trying to change how criminal cases would forever be tried in the United States. Sheriff Shipp made several stops before making his way to the Knox County Jail to get his prisoner. He visited with old friends from his days in the Confederate Army. He had lunch with a friend of the family. When he arrived at the jail, he expected to find Ed Johnson in handcuffs, ready to be transported back to Chattanooga to be hanged. Instead, Shipp stood face to face with the United States Marshal. Johnson wasn't going anywhere. By orders of the federal judge, the prisoner was kept in the Knox County Jail. Already confused, Shipp became even more dismayed when the federal agent handed the sheriff a 9-page petition filed by Pardon and a 1-page order written by U.S. District Judge Charles Dickens Clark. Ed Johnson versus State of Tennessee. Quote, on presentation of this petition, it is ordered that a copy thereof and of this order be delivered to or served on the State District Attorney General, the Honorable Matt Whitaker, at once, as notice that he show cause, if he chooses to do so, against the petition and the writ applied for, on or before 12 o'clock, Saturday, March 10th, in the United States Circuit Court room in the Custom House at Knoxville, Tennessee, until which time action on the petition is reserved. The petition, and especially the charges as to the conduct of the jury commissioner, may, and if disputed, must be answered." Unquote. Done this March 3rd, 1906. C.D. Clark. Quote, "What does this mean?" Unquote, Shipp asked. Quote, "It means you may not have the prisoner," unquote, responded the marshal. Quote, "He's now officially in the custody of the federal courts pending the hearing next week. I'm under orders to have him remain housed here until the conclusion of the hearing," unquote. The sheriff was shocked. There had been no speculation that the lawyers would take their case to federal court. These local authorities had never experienced such a legal maneuver by criminal defense attorneys. This was the first time a state prisoner from Hamilton County had filed a federal habeas corpus petition since Shipp, Whitaker, and McReynolds had been elected to office. Can a federal judge do this? Does he have the power to interfere like this? The sheriff inquired. The Knox County sheriff, in whose jail Johnson was lodged, shrugged his shoulders. The federal marshal remained silent. Shipp took the court papers and shook his head in disbelief. An hour later, he was on train headed back to Chattanooga without a prisoner. Writ of habeas corpus. Chapter 9. Noah Pardon walked into the U.S. District Court in Knoxville on Saturday, March 10th, with great confidence. With Stiles Hutchins and Lewis Shepard at his side, the lawyer placed his old leather briefcase on the dark wooden table at the front of the large, majestic courtroom. Every pew was packed. Half of those in attendance were black, and they all sat on the same side of the courtroom, in the rows behind Pardon and the defense team. A few white people were scattered in with them. Seated directly beside the defense lawyers were Hamilton County Assistant District Attorney E.S. Daniels, District Attorney Matt Whitaker, and Criminal Court Judge Sam D. McReynolds. The benches behind them were filled with their supporters, who were exclusively white men. Sheriff Shipp and two of his deputies sat in the first row. Upon entering the courtroom, Pardon approached the prosecution table to say hello, but none of the Chattanooga court officials responded or even looked at the black lawyer. They refused to recognize he was there. The biggest surprise for Judge McReynolds and the other state officials came when they saw Shepard join Pardon at the defense table. They had no idea the former Hamilton County judge was assisting the black lawyers. Immediately, they suspected Shepard was behind the entire plot to stall the execution of Johnson. After all, it was Shepard who had criticized the judge and prosecutors during the closing arguments of the Johnson trial. McReynolds was furious. Not only was he outraged that the criminal conviction had been appealed into federal courts, but he was convinced that Shepard was doing it simply to embarrass him, that the proceeding was designed to humiliate him as a judge by putting his rulings and his handlings of the Johnson case on trial. He regretted the day he had appointed the flamboyant lawyer to the Johnson case, and he vowed never to give Shepard such courtesies again. The language of the petition was strongly worded and highly critical of McReynolds and Whitaker, and they blamed Shepard for all of it. At that moment, the U.S. Marshal opened the side door of the courtroom. Marshal: "All rise. Hear ye, hear ye. The United States Circuit Court of the Northern Division of the Eastern District of Tennessee is now in session. The Honorable C.D. Clark presiding." All those having business with that court draw nigh, and ye shall be heard. God save the United States and this humble court. Be seated. Judge Clark. Mr. Clerk, will you call the case before us? Clerk. Ed Johnson versus the state of Tennessee in the criminal court of Hamilton County. Judge Clark told the marshals to escort the defendant into the courtroom. Johnson was seated beside Shepard. With the formalities out of the way, the judge instructed the defense to make any opening remarks. Pardon stepped to the podium to deliver a summary of the accusations against the state. The lawyer's statement closely followed the written petition he had filed in the case. His presentation resembled a Sunday morning sermon more than an oral argument on the law in a federal court. He waved his arms. He pointed fingers. He whispered, then shouted. His voice was filled with outrage and bewilderment. At key moments, he would pause and simply shake his head in disgust. Above all, he told the story of Ed Johnson and how he had been railroaded through the Hamilton County criminal justice system. We contend, Your Honor, that he is illegally restrained on his liberty by the sheriffs of Hamilton and Knox counties. He was illegally and improperly put on trial for the offense of rape and illegally and improperly convicted thereof and sentenced to death. In a very theatrical style, Pardon told the judge about the lynch mob that had attacked the jail the night of Johnson's arrest. He praised Sheriff Shipp and the deputies for their, quote, hours of bravery and strenuous resistance in beating back the infuriated mob, unquote. He praised the lawmen for suppressing 2 subsequent attempts by the mob to raid the jail. Pardon then surprised the state authorities by telling Judge Clark about a secret meeting called by Judge McReynolds about a week before the trial. Present at this clandestine meeting were Whitaker, Shipp, the mayor of Chattanooga, and 2 of the defense lawyers appointed by the judge to represent Johnson. The meeting, according to Pardon, was to determine what actions should be taken to prevent mob violence. Judge McReynolds and the other state officials were astounded. How had Pardon learned about the meeting? The information must have come from Shepard. They were outraged and distraught. Quote, in that meeting, Your Honor, defense counsel informed the judge and the attorney general that the defendant could not get a fair and impartial jury in Hamilton County. The excitement against him was so high that he could not get a fair trial, and that it was his duty to apply for a change of venue to another county, or they ought to make application to continue the case until the next term of court, trusting that the excitement and prejudice against the prisoner would subside. The judge informed the petitioner's counsel that he was not going to grant a change of venue, that he was going to try the case on the day fixed. Petitioner's counsel were advised at that meeting that if they made an application for a change of venue or to continue the case, the mob again would attack the jail with more success than they had attended their former effort, and would succeed in murdering the petitioner. Petitioners' counsel were alarmed by the threats made almost ex cathedra, and solely on account of the fear aroused by those threats, they did not make any application for a change of venue or continuance. To help calm the lynch mob mentality, the officials at the meeting had agreed to tell a reporter from the Chattanooga Times that Johnson would be put on trial immediately in Chattanooga, and that there would be no further delays in the case. Pardon told Judge Clark. He said the judge and sheriff hoped these measures would satisfy the agitators. However, this meeting and its results prejudged any motion for a change of venue or a motion for a continuance of the trial. The secret meeting was not part of the open and public trial, and an obvious violation of the defendant's right to due process. Pardon said police officers surrounding the courthouse every day of the trial, preventing people not associated with the case from going into the building. As a result, he said, Johnson's mother, father, sister, pastor, and other friends were shut out. Only a few select members of the local bar and supporters of Judge McReynolds and Sheriff Shipp were permitted in the courtroom during the trial, said the lawyer, his voice rising to a zealous pitch. Quote, the young lady upon whom the rape had been committed testified that she believed the petitioner was her assailant, and thereupon a juror burst out crying, and with a wild gesture toward where the prisoner was standing, said, quote, if I could just get at him, I would tear his heart out, unquote. At least two of his fellow jurors remonstrated with him, but the presiding judge did not rebuke the juror by word or gesture or disapproving look, unquote. The makeup of the jury was Pardon's next target. The lawyers said the Constitution entitled every criminal defendant to be tried by a jury of his peers. Johnson was not afforded that right. Pardon reminded Judge Clark that the U.S. Supreme Court had ruled in 1886 that it was a violation of the 14th Amendment's Equal Protection Clause for states and counties to exclude black people systematically and intentionally from being called as jurors. Yet, he said, that was exactly what happened in this case and every case being tried in Hamilton County. A community where 1 out of every 3 people was black, but where none ever sat as jurors. Quote, the jury commissioners illegally refused to put the names of Negroes in the jury box, although there were 5,000 Negro males between the age of 21 and 70 in Hamilton County, and more than 3,000 of whom are eligible for jury duty in respect to their intelligence, upright character, and property. The jury commissioners arbitrarily refused to put the names of any of them in the jury box, or if 2 or 3 of the names got in the box, it was an accident, which was remedied by the commissioners and judge as soon as the fact was discovered. The names of these 3 eligible and qualified persons were excluded from the jury box solely because of the fact that they belonged to the Negro race, unquote. Pardon told Judge Clark this was not by chance. 36 men had been summoned for jury duty in the Johnson case. All were white. If there was any jury that local authorities were going to keep black people off of, it was this one, the lawyer said. Pardon's final point may have been the most emotionally charged. He said that 3 lawyers appointed to defend Johnson had abandoned their client after the trial. As a result, the defendant was denied his constitutional right to appeal his conviction. The lawyer said the 3 trial attorneys had done the best they could under the circumstances. However, the attorneys felt the pressure of the lynch mob when they decided not to seek a new trial for Johnson, thereby forgoing his opportunity to challenge the verdict on appeal. True, the lawyers did give their client the final say, he said. The 3 attorneys told Johnson he could accept the verdict and be executed by the state of Tennessee, or he could appeal, and the lynch mob would take him from the jail, beat him, and murder him. Plus, the mob might kill other black inmates at the jail while they were there to get him. Pardon said those were not real choices. Quote, like a lamb being led to the slaughter, he was dumb, unquote, Pardon told the court. Believing that Johnson's 3 court-appointed lawyers had abandoned their client, Pardon said, he and Hutchins had stepped forward to take up the appeal. However, he said Judge McReynolds had refused to accept their motion for a new trial. The judge also tricked them into a procedural snafu by telling the black lawyers not to file their petition until the following day, and then ruling that the time limit for making a motion for a new trial had expired the day before. With sweat streaming down his face, Pardon thanked Judge Clark for his indulgence and returned to his seat in the courtroom. Hamilton County District Attorney Matt Whitaker gathered his papers and walked to the podium. After introducing himself to the court, he immediately launched into a full-scale attack on Pardon, Hutchins, and Shepard. He denied every single point in their petition. Quote, these charges are utterly false, without foundation, and made evidently of a desire to misrepresent the judiciary, and made with a malignant purpose and a wicked heart, unquote. In a decidedly spirited tone, the prosecutor told Judge Clark that Johnson had received one of the fairest trials ever performed in Hamilton County. Judge McReynolds had appointed the best lawyers. The defense attorneys were given all of the state's evidence several days before trial, and were allowed to call any witness to testify that they desired. Whitaker adamantly denied that the 3 court-appointed lawyers were ever threatened or intimidated. No one discouraged them from seeking a change of venue or a delay in the trial. Whitaker said the statement by Pardon that a juror had threatened the defendant during the trial was unequivocally false. He said no jurors had to be restrained, and the words, quote, if I could get at him, I would tear his heart out, unquote, were never spoken. What did happen, the prosecutor contended, was that a juror in a low-key voice told another juror, quote, if I knew he was guilty, I would tear his heart out, unquote. Finally, Whitaker blasted Pardon for making untrue and malicious statements about McReynolds. The judge had done nothing to discourage Pardon and Hutchins from filing their motion for a new trial. Whitaker said it was the lawyers' fault they waited too long to notify the court, and that they wanted to seek a new trial and appeal the verdict. Judge McReynolds, he said, was simply following the rules of court and denying their motion. Besides, the entire proceeding in federal court was nothing more than a delay tactic designed to give Johnson a few more days of life. The claims made by the defense attorneys had no basis in fact or law. The prosecutor argued, and therefore, the petition should be immediately dismissed. With opening statements out of the way, Judge Clark told the lawyers representing Johnson to call their first witness. He was Foster V. Brown, one of the 3 Chattanooga lawyers appointed by Judge McReynolds after the trial to advise Johnson's 3 trial lawyers regarding the merit of an appeal of the conviction and death sentence. Brown said one of the other 2 lawyers appointed to consult with the trial team believed an appeal would lead to a lynching. Shepard. What was the statement by the lawyer as to the effect upon Johnson if an appeal was prosecuted? Brown. He had seen a man that morning whom he said was a good citizen and opposed to mob violence. But the man said if Johnson took an appeal, that he himself would head a mob to lynch him. Shepard. Did the lawyer say anything about the action of the police in having protected Johnson up to that time, but that they would withdraw their protection from him if an appeal was prosecuted? Brown. He said someone in high authority in police matters stated that if Johnson took an appeal, the police department would not afford the sheriff the protection which the police had theretofore afforded. That this was the thing that impressed me, because I lived near the jail, and I saw how powerless everything was unless the police were there. Thoroughly impressed that to attempt an appeal meant that Johnson would have been mobbed, and the statement was made that it not only involved the lynching of this man, but of others that were in the jail. Unquote. Under cross-examination, Brown said the 3 trial lawyers, including Shepard, expressed the opinion that there were no errors in the record and that an appeal would most likely be futile. He said the other lawyers depended heavily on Shepard's guidance and input. Whitaker: how much experience do you have in the criminal law? Brown: not very much. Whitaker: Judge Shepard is regarded as the leading criminal lawyer in Chattanooga, isn't he? Brown: unquestionably. Shepard: the best lawyer of any kind, too. Whitaker: after everything was talked over concerning the case, what had been done by the judge and the jury and everybody connected with the trial, you all came to the conclusion that it would affect no good purpose if an appeal was taken. Brown: yes, but I will qualify that Judge Shepard and I said we did not believe it would avail anything if appealed. But I would not say I would not have taken an appeal but for the peculiar situation of the public mind at that time. Unquote. Shepard's next witness was W.G.M. Thomas, one of his co-counsels during the Johnson trial. Shepard asked Thomas to tell Judge Clark about the private meeting between McReynolds, Whitaker, Shipp, and others that took place a few days before the trial. Thomas said he had attended such a meeting, during which he suggested to the others that the trial should be delayed so that the defense attorneys could better prepare and the racial tension in the community might settle down. Shepard: state whether in the meeting we had, I'm going to say this again. Shepard: state whether in the meeting we had with Judge McReynolds and the Attorney General, whether those gentlemen said it would be dangerous to the life of Ed Johnson if we made an application for a change of venue. Thomas: yes, if we made any dilatory move, it would inflame the spirit of the people. Shepard: state whether you mentioned that you felt it'd be your duty to make an application for a change of venue and for a continuance of the case on account of this feeling. Thomas: we did not make this move because we were afraid there would be a lynching if we did. The conditions were such that, in my judgment, it was unsafe. If we made a public application for an extension of time or for a change of venue, I understood that the people hearing of this would rise up and we could not avoid a mob. Shepard: what did Mr. Whitaker say about having had an interview on the Sunday night before the trial with Governor Cox? Thomas: he reported to us that troops would not be furnished, that the governor said the case ought not be tried, or, if tried, it ought to be tried in Nashville. Shepard: tell us about the meeting with the 3 lawyers Judge McReynolds appointed to advise us. Thomas: I wanted to know whether anything could be accomplished by appealing. In other words, was there reversible error in the record, and that by taking the case to the Supreme Court, whether or not anything could be accomplished by it, or was it merely a question of continuing a human life? The lawyers present gave their opinion that the lawyers representing a defendant in a criminal case did not owe to him the duty of merely continuing his life, and if an appeal would mean merely a continuance of a human life, without more, that was not the duty of a lawyer representing a criminal, and second, that there was no reversible errors as discovered in such a way as to grant a new trial, and in the third place, that an appeal would mean a lynching. Shepherd. What was said with respect to whether or not a lynching would occur if we took an appeal? Thomas. If we prosecuted an appeal, the jail would be raided, and we would have another uprising in the city. Shepherd. State whether or not the lawyers present gave evidence of what they had heard. Thomas. One lawyer had heard at least 25 men that morning say that an appeal would mean the lynching of this defendant. Shepherd. Was anything said about them going to lynch the lawyers for the defendant if they persisted in an appeal? Thomas. Yes. It was said a dilatory movement would wind up lynching the judge, the lawyers, and everyone else. Thomas. End quote. Thomas told the judge that he had practiced law in Chattanooga for 2 decades. However, he had never seen a case in which a black person was in the jury pool. The next witness was J.P. Pemberton, the deputy clerk of Circuit County of Hamilton County. He was the person responsible for summoning all jurors for criminal and civil trials in the county. Pemberton said they kept about 4,000 active names in the jury box at all times. However, he could only remember one instance in which a black person had ever been called for jury duty. He said that man was, quote, almost white, unquote. District Attorney Whitaker was the next to testify. He denied that any threats or statements of intimidation were made against the 3 lawyers who defended Johnson at trial. No one had discouraged or prevented the defense attorneys from seeking a delay in the trial or a change of venue. Whitaker said he personally knew that 3 black people had served on juries in Hamilton County during the past several years, though he could not give one name or cite which case. Finally, he said Johnson was an adult who had made the decision not to appeal his conviction, and now the defendant must live with that. Judge McReynolds was the last witness. From the start, it was obvious that bitter feelings existed between him and Shepherd. As soon as McReynolds stated his name and official position for the record, he turned to Judge Clark and asked to make a statement before answering any questions from Shepherd. The federal judge agreed. Quote, I hope the court will pardon me, but there are some things in that petition that apply solely to me as an official. I want to say that they are statements that are maliciously false. Anyone can make infamous and slanderous statements like those in the petition, but it is a different matter to prove them. When they charge that I, outside of my courtroom, said I would deny a continuance or change of venue, they utter an infamous falsehood, and I believe the man that wrote it knew it was false when he wrote it. It is also charged that I refused Johnson's father and mother admission to the trial. That is also false. At that time, I did not know even that Johnson had any father and mother. For his part, unquote, Shepherd said that none of the claims in the petition were intended to offend Judge McReynolds personally. However, he refused to withdraw or apologize for the allegations. Instead, he continued to ask pointed questions of the criminal court judge. Specifically, he queried the judge at length about black people's being denied seats on juries. He also explored the judge's refusal to allow Pardon and Hutchins to seek a new trial for Johnson. Quote, Shepherd, what about the charge about getting Negroes off the jury? Judge McReynolds, all I know is that I've appointed 3 good men, as I thought we could find as jury commissioners. We have absolutely nothing to do with the drawing of the juries. When we want a jury, we make an order that the jury commissioners draw so many jurors, and that I have absolutely nothing to do with it. I want to say that I have heard the report circulated that there was a Negro by the name of Will Campbell on a jury. Shepherd. What about other Negroes? Judge McReynolds. I do not remember seeing any Negro there on the jury, but I think there was one other that asked to be excused on account of being hard of hearing. Shepherd. Why did you deny the motion for a new trial filed by Attorney Pardon? Judge McReynolds. I never heard anything about any other attorneys getting into this case until Monday morning. At that time, Pardon and Hutchins came to my office and said they wanted to relieve me of the responsibility of this man being hung. Hutchins said, quote, Judge, you will give us 30 days to make out a bill of exceptions, won't you? Unquote. Pardon said, quote, I want to have a talk with you and the Attorney General to see if we can not arrange to appeal this case without bringing Johnson back from Knoxville, unquote. I told them I would not discuss this